Number 2, estate planning myths. Estate planning is a process that takes place while one is alive and able. It addresses the issues of protecting a person's quality of life and assets during times of disability. It includes a plan for the transfer of assets at death to a person's intended beneficiaries. For a married couple, having an estate plan in place often determines the quality of life of the surviving spouse. There are husbands who are reluctant to engage in estate planning. I'm not sure what the real reason is. Maybe it's too uncomfortable a topic for them. Maybe they think it's unnecessary because my wife will get everything anyway, right? Or, as her husband, I have the legal authority to make financial and healthcare decisions for her if she can't, right? Or, well, it's not like I'm going to die tomorrow. Whatever the real reason is, the reluctant husband commonly uses the cost of the planning as the excuse for not going forward. The truth is that the status of husband, wife, or partner does not give a person legal authority to make financial and healthcare decisions for a disabled spouse. Such authority is provided by establishing an estate plan. If there is no power of attorney or advanced healthcare directive that provides financial and healthcare decision-making authority, then the healthy spouse will have to go through the guardianship process in court. The average cost is $10,000 in fees and costs. The truth is that when a person dies without an estate plan in place, the Delaware intestate statute, died without a will, determines who gets what and when. For example, a surviving spouse does not necessarily inherit 100% of the assets the deceased spouse solely owns if children from a different relationship survive that person. Take the family home, for instance. If it was solely owned by the deceased spouse, then the surviving spouse receives only a life estate. The remainder interest goes to the stepchildren. The surviving spouse cannot sell the house without the permission of the stepchildren. The lesson here is not having an estate plan in place can be costly on many levels for a caregiving spouse whose loved one suddenly loses their independence. It can also contribute to the surviving spouse's financial impoverishment. Delaying your estate plan is penny wise and pound foolish.